So Michael Popok, Legal AF, for just the second time in 25 years, the United States Supreme Court is going to be playing an outsized role in helping pick who is the President of the United States. It's deja vu all over again, right? History is prologue. In 2000 in Bush versus Gore, a divided Supreme Court that John Roberts, the current Chief Justice, was not on, decided that the president should be George W. Bush and not Al Gore. You can fill in the blanks as the historical ramifications of that particular decision, which still reverberate today, especially in foreign policy. They made that decision based on a ruling that they made coming off the Florida Supreme Court, which was about to hand the election to Al Gore, the winner of the popular vote, and apparently on paper at least, the winner of the Electoral College, but not according to the Supreme Court, who over a 72-hour period and briefing and oral argument stopped the count in Florida and gave the election over to George W. Bush. We're seeing it all over again right now. The Supreme Court is influencing the impact and impacting the 2024 election two ways. One of it is with rulings they are going to make and are about to make over the next month or month and a half about Donald Trump, his ability to be on the ballot in certain states, whether he is an insurrectionist or engaged in insurrection or rebellion or not, and whether he's entitled to any type of immunity that would stop any of these criminal cases against him, is the ones specifically in the District of Columbia and in Georgia. And that is the way they're going to influence over the next really 4 weeks in their decision-making whether Donald Trump is or is not going to be convicted of a crime before the November election. In addition, let's not let the U.S. Supreme Court off the hook before I go back and talk to you about the specifics of the appeals that will be brought in front of the Supreme Court starting as early as the first week in January. Let's think about all the things that they have done to influence the outcome of the election by way of their own policymaking in the decisions that they've made. Let's start in March of last year, March of 2023 or this year, in the Dodd decision, in which they ripped away a constitutional right for a woman to choose her bodily autonomy, whether she was going to have an abortion or not have an abortion. That was enshrined in case law starting with Roe versus Wade. But according to the Dodd decision written by Sam Alito, a woman never had that constitutional right, that was a constitutional debacle that needed to be corrected, a historical wrong, constitutional wrong that these MAGA members of the Supreme Court needed to resolve, and they did it. And the result has been that every major special election since then, and every major election that's happened in the states, has really gone to the side of the Democrats, because so many voters, women, yes, but men supporting women also, have gone to the polls against the Republican Party, who continues to cling to the notion that a woman should not have equality in this country or the right to choose. And by having that as part of their platform, we hope they're doomed to failure in national politics. Starts with Sam Alito, the leak, if you remember, of that draft decision, which made concrete and stopped all of the horse trading and all of the discussions that may have led to a better compromise decision. It sort of stopped it in its tracks. And the final decision that was eventually issued several months later matched the leak in March almost verbatim, at least where it mattered. And so that's one way the politics of the United States Supreme Court, which is not supposed to be the political body, influences the outcome of the election. Of course, other decisions as well. It's decisions about the Second Amendment, expansion of Second Amendment rights, especially in the face of a rising epidemic of mass shootings in America. We just hit a very unfortunate record in 2023, and we're not even done yet. We haven't even put the tally in the books yet for the rest of December, and we've already hit a record for most mass shootings and deaths by guns. And so we have a U.S. Supreme Court doesn't care about that, cares about what our old-timey ancestors in the 1800s felt about gun control, and that is the dead hand of history that's supposed to control how we regulate guns, ammunition, weapons of mass destruction, military-grade weapons in the hands of citizens today. according to this U.S. Supreme Court. And that animates and motivates and drives people to the polls as well, on both sides of the polls. But, you know which side this particular podcast is on. And so we've got a number of rulings dealing with fundamental issues of personal liberty, of personal privacy, of sexual privacy, that the U.S. Supreme Court has weighed in on. And of course, they've crossed and jumped over, we jumped the shark, as we used to say, and jumped the wall that separated church versus state in a series of decisions in which they have almost invariably sided with religious organizations and religious expression over what our founding fathers believed should have been a separation of church and state, where there shouldn't be state-sponsored religion. And they've come dangerously close to that in a series of decisions that started the term last year. So between the religion, church, and state separation wall being disintegrated by the U.S. Supreme Court, decisions about a woman's right to choose that went against that and set them back 100 years, if not more, women, and then finally decisions about gun rights and gun control, which is just completely antithetical and hypocritical to the situation we have today with mass shootings. We've got all of that political agenda. Now let's return to what they're supposed to be doing, which is passing laws. And let me talk about those laws in particular as they relate to Donald Trump and link them back to the topic of the hot take here, which is the influence outsized of the U.S. Supreme Court on the outcome of the election. There's two major issues that are going to be coming up to the United States Supreme Court as early as January the 4th, if not earlier, and then one that the U.S. Supreme Court decided to take on their own. All relate to Donald Trump and impact Donald Trump one way or the other. In no particular order, the first thing that the United States Supreme Court has done this term in the last week has decided that they will review on appeal the question of whether the events that happened on January 6th, the attack on the Capitol, what we like to refer to as the insurrection, was that properly charged by the Department of Justice as a corrupt obstruction of an official proceeding, the official proceeding being Congress in session, trying to get together to certify the Electoral College and the electoral votes. Was that law that the prosecutors used, put on the books in 2002 during some white-collar financial frauds like the Enron debacle, which was like the FTX fraud of its day? Is it being properly applied to a group of people that attacked the Capitol and went after and tried to assassinate elected officials and their staff in order to stop the peaceful transfer of power? Is that a proper application of that law? And it matters not just for the 300 Jan 6 defendants that have been convicted either by bench trial, jury trial, or by plea of that particular charge, which carries with it a 20-year sentence. It's the second highest charge in the arsenal of the prosecutors in charging their cases and in negotiating plea deals. First high is the seditious conspiracy. That was reserved for like Oath Keepers and Proud Boys and others. And then the next level down is obstruction of an official proceeding. So if that goes, not only do 300 or more defendants get their sentences vacated and get their convictions vacated, at least to the extent that that was part of the sentencing process, but Donald Trump would win because he'd get 2 of the 4 conspiracy claims that are against him brought by Jack Smith, the special counsel in D.C., dismissed. He'd be left with 2 more, so we'd have 2 more to try in March, but the two at the highest point value, the highest dollar value, if you will, would be stripped away. So that the United States Supreme Court is going to get around to ruling. I don't know if they're going to do it on a fast track or they're going to do it on their normal track and issue a ruling in June. They issue a ruling in June or sometime in April, May, or June, they'll just miss probably the trial of Donald Trump on the 2 counts that they now have up on review, because hopefully that trial in the District of Columbia will take place in March. So we have a little bit of a mismatch there. And one of the ways you solve for the mismatch is somebody like the Trump side moves to have some sort of emergency appeal and maybe a stay issued, and we're off and running. So that's one thing that they're going to decide that will have a major impact on what Donald Trump is tried for in front of a jury and what they can convict him of prior to the November election. The second issue that they are going to have to make a decision about that will impact the outcome of the 2024 election has to do with immunity. Whether Donald Trump has some sort of absolute or presidential immunity because he used to occupy the office for everything that he did, or whether there are things outside the color of his office that clearly go to non-presidential crimes, which is sort of where we are with the indictment, both in Georgia and in the D.C. election interference case. And now, once and for all, the United States Supreme Court, not at the moment, but after the D.C. Court of Appeals makes its decision in mid-January on this issue, three-judge panel, thumbs up or thumbs down. The three-judge panel is Judge Pan, Judge Childs, and Judge Williamson. Two of them are Biden appointees, and Judge Pan has been very vocal in her writing about Jan 6 issues. I would be shocked if the D.C. Court of Appeals ruled for Donald Trump. I think they're going to rule for the special counsel. They're going to support Judge Chutkan, the trial judge's decision that there is no presidential immunity for the indicted charges in the District of Columbia, and that Donald Trump can't use it to dismiss the indictment. Nor do I think they're going to buy the argument led by Donald Trump that somehow because he was impeached by the House but not convicted by the Senate on Jan 6 issues, he got a get-out-of-jail-free card. He doesn't get to be indicted as a civilian ever again because only Congress, this is the argument, only Congress can resolve the issue and he was not convicted. I don't think that prevails either. Any kind of what we call double jeopardy argument. And so that'll be decided. It'll be, there's an oral argument on January 8th. They'll make their decision. And then from there will be an appeal, I'm sure, expedited, I hope, to the U.S. Supreme Court. What you heard last week is that the U.S. Supreme Court declined to take a direct appeal on the issue. They don't want it that way. They want it to come up the normal way, right? Don't leapfrog over anything. You go trial court, intermediary court, D.C. Court of Appeals, Supreme Court. Do it that way. And I think before the end of January, they will have full briefing and maybe even oral argument on this very important issue. I don't think they're going to just put it on the back burner and go, we'll just handle this in our normal way. We'll see you guys in March or April for oral argument and we'll make a ruling in June. I don't think so. I think immunity, because it has effectively stopped, put a pin in the case, the trial itself is sitting on ice. They're going to have to make a ruling soon, or we're going to lose the March. The people of the country are going to lose the March 2024 trial date for Donald Trump. So they're going to make that decision as well by the end of January. So you've got, and then lastly, this Colorado Supreme Court issue, where the Colorado Supreme Court, in a 4-3 decision, found that, and I want to break that down for a minute, found that the Colorado Secretary of State can and should ban Donald Trump from the ballot, both the primary ballot and the presidential ballot general election, under Colorado state constitutional law, because all the judges that have looked at the issue in Colorado, not just the 4 that voted to ban him, all of the 8 Colorado judges, from the trial court up to the Republican judges and the Democratic judges, all have found that Donald Trump effectively engaged in insurrection or rebellion against the Constitution, as that term is used in the 14th Amendment to disqualify him. The only rub, the only fallout between the 4 and the 3 in Colorado in the 4-3 decision was that the 3 said, he engaged in all that stuff, and it looks like the 14th Amendment applies to him as a president. But we don't want to do it. Can Congress do it? Maybe Congress would be better. Let Congress decide whether he should be on the ballot, or maybe the Electoral College. And one of the justices said of the Colorado Supreme Court, we know he did all these things, but he wasn't charged with insurrection or rebellion. I'd rather see a conviction and a crime, even though the 14th Amendment doesn't say any of that. That was their way to punt. But make no mistake about it. 8 different judges of Colorado looking at the issue saw an insurrectionist and somebody participating in rebellion when they know it when they see it, and they saw it in Donald Trump. And so that issue, which is going to be on appeal on January the 4th, with a paper filed by Donald Trump up at the U.S. Supreme Court from the Colorado Supreme Court, is going to be decided, I guess, also sometime in January, maybe the beginning of February. So look at the issues that the U.S. Supreme Court right now are teed up to be heard really in January or early February. You've got, during the primary season, by the way, you've got, as I've outlined, you've got That is the question: should the people like Donald Trump and 300 other Jan 6 defendants, should they have been charged because of their actions, indicted actions, should they have been charged with obstruction of an official proceeding, or was that an overcharging by the prosecutors? Does that law apply and properly mapped onto these alleged facts, yes or no? That's a big decision, because if the Department of Justice loses, 2 of the counts for Donald Trump go out the window, and then you see what happens with the trial before the election and the impact on the election. That's one. 2, they're going to have to decide whether Colorado is right or wrong about finding that Donald Trump had engaged in insurrection or rebellion, that the 14th Amendment, Article 3, applies to presidents. That was another issue. And whether secretaries of state under their unique constitutions of their state can ban people from the ballot. That's going to be decided over the next 4 or 5 weeks. And then you've got this fundamental issue, which has to be decided, I think, of all those things, really first. I think the first appeal, if we're doing this air traffic controller, the first plane to get cleared for takeoff is going to be the one about presidential immunity, which is going to be up to the Supreme Court, but only after full briefing, oral argument, and ruling by the D.C. Court of Appeals, which will happen by mid-January. Then there'll be an appeal by the loser to the U.S. Supreme Court, who I expect will put it on a fast track, and they will make the decision whether, just because you happen to occupy the Oval Office and you have a number after your name for the president that you were, that you can commit crimes and you can't be prosecuted for them in our court system. Terrible precedent if that's the precedent. And it would be against the line of cases dating back even before Richard Nixon if this U.S. Supreme Court, in its 6-3 sort of MAGA majority, rules that way. Think about the precedent. This isn't just about, to paraphrase Clarence Thomas in a speech at one time, this isn't just about current events. This is about history for the long term and the Supreme Court's position and legacy in that history. And John Roberts, the Chief Justice's legacy here. Is his legacy going to be on his watch? The Roe versus Wade, a constitutional right for a woman to choose, was ripped out of the books and torn up and left at her feet. And then later on, he chose a president in the form of Donald Trump because he found that there was presidential immunity that banned any kind of prosecution against him for the things that he did that have all been outlined at length by the Jan 6 committee and other places. That's okay because he happened to also win the golden ticket of being the president. Is that going to be John Roberts' legacy? Or is he going to be able to do some horse trading here on a number of these cases I just outlined and get to consensus and a majority to set precedent that helps protect and reinstall the guardrails around our democracy? That's going to be the question. And our liberty and our justice and our republic, our constitutional republic, hangs in the balance, unfortunately. So we're going to have to see what happens. And then, of course, I'll do another hot take on, should Clarence Thomas even be making any of these decisions at all? Should this be a 9-justice decision? Or should it just be 8 because of Clarence Thomas having his fingers in all the pies, in all the wrong pies, because of his wife, Ginny Thomas, and his own corruption issues? And Ginny Thomas, basically being an insurrectionist in her own right, trying to campaign and lobby to stop the peaceful transfer of power. And so shouldn't he, for the good of the country, for the good of his own reputation, shouldn't he recuse himself? I mean, they had Ketanji Brown Jackson recuse herself from the Harvard affirmative action case because she happened to go there. I mean, if that's all it took, why is Clarence Thomas even thinking about being one of the 9 to make the ultimate decisions on the cases that I'm talking about? But we'll have to follow that as well. I do my work at the intersection of law, politics, and justice. Only one place, the MeidasTouch Network. And on a podcast we call Legal AF, the podcast. Yep, it's exactly what you think by the title. It's Wednesdays, it's Saturdays at 8 p.m. Eastern Time. And I do it with my co-anchor, Karen Friedman-Ignifilo, and with Ben Meisalis on Saturdays. And on hot takes, just like this one, about every hour, if not every day, at that same intersection. You like what I'm doing? Leave me a thumbs up and a comment. And then follow us on Legal AF here on the MeidasTouch Network. and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.